Insurance companies in Australia are heavily regulated because the collapse of an insurance company or an insurance company unable to pay out on claims would obviously cause great distress to many people. Under these powers, the Federal Treasurer can establish investigations into an insurer and can issue instructions to that insurer. In this case, the Treasurer became concerned about the viability of marine hull and liability insurance, and while an investigation was underway, the Treasurer issued directions that the company must not issue any new policies, renew any old ones, or dispose of any assets. The company was not given any procedural fairness in relation to the decision, so they were not given an opportunity to know why these decisions were being made or to respond to the need for them. The company challenged this decision. In the federal court, the Commonwealth Government raised a number of circumstances in which administrative action could be taken without affording procedural fairness in circumstances of urgency. Justice Wilcox agreed that sometimes this might be true. He said, "There may exist statutory powers which, by their very nature, are inconsistent with an obligation to accord an opportunity to be heard. For example, a power to destroy dangerous animals or forcibly to enter premises at a time of fire or natural disaster. It is not difficult to impute to the legislature, by the very specification of the power, intention to exclude a hearing in such cases." However, he said the more difficult cases were those where the intrinsic nature of the power was not urgent, but sometimes that power might need to be exercised in great urgency. In that regard, he said the authorities were mixed. He identified the view that in cases where the power may, but not necessarily will, have to be exercised urgently, the general obligation to afford a hearing remains, but that it is inapplicable to particular cases where urgency is proved. However, he then noted more recent authority from the Privy Council to the effect that if procedural fairness was required, it must be granted, but that the nature of procedural fairness might have to be adapted to the urgency, for instance by truncating the time frames for a person to be heard. In the marine hull case, though, he found that there was no circumstance of urgency and procedural fairness should have been provided to the insurer.